What does it mean if a doctor has been sued 40 times during the course of their career, and now you learn for the very first time that that doctor has a history of all those lawsuits and you think that something was done wrong? Come join me. I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial attorney practicing law here in the state of New York. The answer to the question may surprise you. You may think that just because the doctor has been sued so many times before automatically means that something was done wrong in your particular case. I've had many people come to me saying, oh, I heard about so many people, so many patients who brought lawsuits against that particular doctor that surely something must have been done wrong in my particular case. The answer is entirely different, and here's why. The mere fact that a doctor has been sued does not in and of itself mean that there was wrongdoing. In a malpractice case here in New York, we are obligated to get medical confirmation by an expert who's reviewed all of your records to confirm that you have a valid basis for a case. Only then are we permitted to bring a lawsuit. Only when a case has gone to a jury verdict and a jury makes a determination that the doctor was responsible for the patient's injuries and now becomes obligated to pay and compensate the patient for those injuries, can we then say that the doctor has established a pattern of neglect that led to those particular injuries. The mere fact that the doctor has had so many lawsuits and is a frequent guest of the court system does not by itself mean that there was wrongdoing. Now let's say that the doctor settled all of those cases before ever going to trial. Can we use that information in your particular case if we bring a case on your behalf? The answer again is going to surprise you. In all likelihood, we will not be able to. Why not? Because the fact that somebody has brought a lawsuit and the doctor and his insurance company has elected to settle that case before ever getting to a jury verdict, we cannot use that information to conclusively show that the doctor was responsible for your particular injuries. You want to know why? The fact that the doctor and his insurance company have chosen to settle a case may not be evidence of wrongdoing. It may simply be a business decision, and it may be a smart business decision to settle that case to avoid publicity and to avoid a determination, a legal determination, that the doctor was actually responsible. And so why do I tell you this information? I tell you this information because recently there was a news report of a Staten Island doctor, plastic surgeon, whose license was revoked by the state of New York, by the Department of Health. And in addition, it turned out that that doctor had 40 pending lawsuits over the course of his entire 30-year career. And people reading that pick up the phone and call and say, Mr. Oginski, I'm concerned because I just checked and my doctor has had a certain number of lawsuits. Does that mean that I may have a valid basis for a case? To answer the question, to really understand whether or not you may have a valid basis for a case, the only true way to understand that is to pick up the phone and call me. I can answer your legal questions. This is what I do every single day. And you can reach me at 516-487-8207 or by email at lawmed10@yahoo.com. I'm Gerry Oginski here in New York. Thanks for watching.